The redactions are not consistent. And so what I want to understand is, if you're saying it's commercially sensitive, that's the basis for the redactions, then why is there sort of a lack of consistency between the redactions and the documents?
So my team had direct discussions with Stellantis.
Sure, but who's the one that had the Sharpie marker in hand? And
Yeah, so
And you're basically, supporting Stellantis in redactions that look completely unnecessary.
The confidentiality, so we have to wait until someone makes an access to information request to see it? That's your argument? An access to information request trumps Parliament's right to review the documents?
so as far as departments go, I mean, I find it a little bit rich that only maybe 4 or 6 other people other than, because you said everybody at the table had seen it earlier, now you're saying you haven't.
what are we trying to protect here? Okay, so
This Guy's Garage. Like and subscribe.
And Chair, I do appreciate the opportunity to appear before you today to discuss matters related to the agreements between the Government of Canada and Stellantis pertaining to the Brampton assembly plant.
We'll start with Mr. Seeback for 6 minutes, please.
Great. So in your statement, you just said that you're trying to redact, commercially sensitive information, which I understand.
Point of order, Chair?
What I do find.
I'm sorry, this is point of order. I'll stop the clock.
Was there any other opening remarks from any?
They haven't signed on yet. We're waiting for them to sign on.
Thank you, appreciate that.
IT issues. Sorry, go ahead, Mr. Seeback.
Thank you very much. And I respect that you're trying to make sure that commercially sensitive information isn't available. What I have found when I've reviewed this agreement, and in fact reviewed other publicly available documents like the CIF agreement 810-819553, which is related to the agreements that we're talking about today, is that the redactions are not consistent. And so what I want to understand is, if you're saying it's commercially sensitive, that's the basis for the redactions, then why is there sort of a lack of consistency between the redactions and the documents? So, for example, in CIF Agreement 810-819553, you redacted the costs of the various, the funding agreement. But in CIF Agreement, the one that we're talking about here, 813-816-251, the dollar amounts in fact aren't redacted, and the dollar amounts of the other agreement are in that document. Like amendment number 2 of CIF 816-251 puts in the full amount of the $15 billion contribution. So it's not redacted in this document, but it's redacted in another. Can you explain that inconsistency?
the question, I don't have the other agreement that you're referring to with me. However, what I can say is that when we do get a request for documents for committees, in any case, we always approach the companies at the end of the day to make sure that we actually have a process in terms of understanding what they feel is commercially confidential and could be harmful to their competitive position. And we review that with the companies to make sure that in our assessment we also feel that there's some legitimacy to it being commercially confidential. In this case, as I've outlined in the letter to the committee, we feel that the information that is not included or that is redacted, maybe I should phrase it that way, is legitimately commercially confidential. So it's about IP strategies, it's about investments in R&D, investments in CapEx, which could actually give some sense to their competitors and give them some sense of what they're doing and could harm their competitive position. So it's a case-by-case basis. A company may feel over time that it does no longer needs to be protected, and that may change. But as we do it on a case-by-case basis with each company.
Sure. Let's say I accept that explanation on CapEx and R&D and other things. But for example, in the document we're talking about today, 813 CIF agreement 813-816251, you've redacted the provincial funding envelopes. Like, how's that commercially sensitive? Like, you've got the federal CIF and then contributions from the provinces on page 19 and page 20 all of the provincial envelopes, funding envelopes, are redacted. How's that commercially sensitive? These are publicly available funding from the province.
Yeah. So my understanding in terms of what was redacted and not redacted is I think the amounts for all these funding envelopes were released. And what's
the amounts are there, but the actual programs where the monies are coming from are redacted. But these are public programs that would be available in estimates and other things. So, like, why would the programs be redacted? What's I don't understand. You said it's about being commercially sensitive. It seems to me it's inconsistent.
You have an answer. Yeah, please, Denis.
Okay. I can answer this. The redactions for the provincial breakdown of the contribution. It's not the title of the programs, but more about the locations of where that contribution will be dispersed. So, which projects at which location will where the disbursement will happen.
So where the money's going is confidential, is a commercially sensitive, you determine to be commercially sensitive confidential information.
That is what, through consultation with the companies, that's...
And is that what the company requested? They requested that be confidential?
Yeah,
Okay.
Yeah.
So is the process that you go through, the company says we want all of these things redacted and you say yes? Or you say no, that's clearly not commercially sensitive, and therefore we're not going to redact it. I guess what I'm asking is, do you have discretion internally to determine what was redacted for the committee, or was this just whatever Stellantis or which other company said, we consider this commercially sensitive, therefore it needs to be redacted?
I guess what I can answer is that, it's a back and forth discussion we have with companies on a case by case basis.
Okay.
And we play a challenge function in terms of what a company requests to be redacted or not. And we have always in the past, and including in this case, found a reasonable landing ground in terms of what's redacted and what's not redacted.
And how many people in your department have access to these documents to determine the redactions, and what are their levels in the department?
Well, I have, in this specific case, I have the people beside me that were involved in those discussions.
That's it. No one else in the department. No one else had access to these documents than the 4 people sitting here today?
Access to the contribution agreement?
Yeah, the contribution agreement, the unredacted contribution agreement to determine the redactions.
So
quick answer, please.
There would be officers within the program that were involved in the negotiation and the development of these documents who would see those documents, yes. So there is a team within the department that works on all of our contribution agreements. But those are treated commercially confidential, and we don't share that information outside of the department without the consent of the company.
Could you please describe the details of the Strategic Innovation Fund, as it's historically been called, and why it was created? What's its intended purpose?
Great. So thank you for that question. So I may get corrected on this, but I think it was created in 2017. And at the time previous to that, the funding by the Department of Industry, which was at the time, was really focused on very specific sectors, so the automotive and aerospace sectors in particular. And there was a perspective that we were losing out on some very interesting investments that were taking place in other sectors of the economy. So at the end of the day, there was a decision that was made to really have a fund that would be able to capture broader, attractive investments that Canada wants to have, including automotive and aerospace, but actually broadening out in terms of other sectors. And since that time, there's been, I don't have the exact number, but I think there's been 152 projects that have been undertaken under the SIF and now what's called the Strategic Response Fund. There was just over $11 billion that federally that have been invested under that program, and that's for what we think is about just over $75 billion of economic activity in Canada based on those investments. The investments are pretty broad in terms of the sector. So I mentioned automotive and aerospace, but we also have biomanufacturing and life sciences has been a very important recipient, a sector, steel, aluminum, and heavy industries, which at this time, under the tariff threats from the U.S., is all the more important. Digital and emerging technologies, clean technology, critical minerals, artificial intelligence. So you really have an ability to capture the right investments. And the broader context is that other jurisdictions are also trying to create a policy space and a financial attractiveness space. We're trying to attract these same investments. So we are, at the end of the day, trying to attract those investments in Canada with the tremendous benefit. And by and large, provinces typically also support financially these investments. So at the end of the day, there's a recognition by both levels of government the importance of attracting these. Maybe just going back to just a point on redactions of documents, just to be clear as well, is that one of the reasons we also feel it's important to have some redactions is there are sometimes some elements in these agreements that we'd rather not have competing jurisdictions have full understanding of. So that we're able to leverage those investments as the best possible. So just as other jurisdictions do, we do think there's a moments in time when it's better not to release the full information from those agreements.
Mr. Jennings, you're the Deputy Minister. Are you the one responsible for the redactions?
I'm not responsible for the redactions, sir.
So who was responsible for putting the black ink over all of the parts that were redacted? Who's responsible? Who's the one who crossed each line out?
So my team had direct discussions with Stellantis.
Sure, but who's the one that had the Sharpie marker in hand? And
so Stellantis ultimately had to agree to what they were willing to have in the shared with this committee in closed doors. Versus what not. As the document that you have in front of you, the condition of that agreement what Stellantis had asked for is that it be shared in closed doors with this committee, and that is why the redactions were as minimal as they were.
Okay, the motion from this committee asked for all the documents fully unredacted. So why did we receive redacted documents?
So if you wish, I can go through the reasons why we think it's important to protect some commercially confidential
Okay, but I'm just going to stop you quickly there because I think you've done that already with previous questions already, and in your opening remarks you already made reference to some of that. But what I am getting at is that there's 9 parliamentarians around this table. We agreed to a motion that called for unredacted documents. Ms. Goudreau did a good job of saying that in previous parliaments, there's been fully unredacted contracts put forward to this committee and possibly other committees, and done so in a manner that they could be viewed fully unredacted. How come we did not receive fully unredacted documents, much like other committees have before?
Okay, so my answer is first of all that we have a contractual obligation. So the contract clearly signs what we can release and not release, and it has to be agreed to with Stellantis. It was the first reason.
Okay, so which line in the contract stipulates that you have to have redacted contracts sent to parliamentarians?
I'll okay.
There's nowhere in here that said that you have the right to overstep Parliament. I didn't see that written in here. So where do you think that you have the power to disobey the will of Parliament?
It's clause 16.1, and just to be clear, I'm not trying to disobey the will of Parliament. What I'm trying to do is find a balanced way to make sure that you can do the scrutiny you wish to do and protect what's commercially confidential. And I proposed what was done in previous parliaments at both Indu Committee and Envy Committee, where we shared in closed doors very slightly redacted documents with those committees.
How many people within your department have seen this? How many total people have seen this contract fully unredacted?
So I'll turn to my colleagues who may have a better estimate, but it's a handful. But I'm not sure if Stephanie or Denis would have a better number than that.
So, I mean, in addition to those of us at the table, we would have a team of 2 or 3 people who would probably have
Plus if I
a
bit more.
maybe a couple more because on the financial side. So
How
a
many,
team of
sorry?
maybe-
I didn't quite hear you because you were turned towards
Yeah,
him.
no, I mean, I'm guessing on the size here, but I would say it's probably a team of between 4 and 6 people in
Team of
addition to those of us at the
In
table
addition to
here.
you, so about 8 to 10 people. Okay. Mr. Bedard, I have a quick question for you and Ms. Gauthier. Clause 16.1 here, does that supersede Parliament or does Parliament supersede 16.1?
So clause 16 in the contract is a typical confidentiality clause. Those clauses do not override the power of certain bodies, including the courts and Parliament, to compel the production of documents.
Thank you.
Would each SIF agreement or special contribution agreement have a confidentiality clause like clause number 16?
Yes, that is typical for any, and like there's no sectors that we've negotiated with that have not insisted on having some protection, and that's really because they understand the need for us to have that information to do the due diligence, but they also worry that that would reveal commercial sensitive information if it would be public.
And are these clauses pretty much standard between SIFs and SCAs, or do they sometimes differ depending on the specific negotiation?
So we always start from a standard contribution agreement. So there's sometimes some very specific negotiations across sectors. So, for instance, the AI sector will have a lot more atypical clauses on IP, as an example. But by and large, they're typical, and this one in particular would be typical across almost all agreements.
And prior to the provision of such a document to parliamentarians, what kind of consultations would happen internally? You mentioned Stellantis. Is there any other consultations? Would provinces be consulted, since there's, in this case, a provincial contribution?
Yes. So we work with, I mean, in this case, Ontario was also a contributor to this project. So we do share information that's relevant so that we can actually, as we kind of proceed with the investment decision, it is of interest to sort of understand, like, what are the issues that they're raising, what are the risks they're seeing, and so we think we can actually optimize how we finalize the agreements. But our agreements are signed, are not shared with Ontario, and nor is Ontario shared with Canada. So we have a general discussion to make sure we understand each other's positions and perspectives, but we don't share the actual agreements.
And maybe at a certain level of...
I'm sorry, Mr. Radici, that is our time.
Okay.
I have to say, I am honestly shocked to hear that the department put Stellantis ahead of an order of Parliament. The idea that no one even raised the possibility of giving us the full contract is just, to me, unbelievable. And it looks like Stellantis was just, they walked over our request, and this is, it's an outrage, actually. And now we see that Stellantis can't even manage to fix an IT problem and appear here at committee to answer some of the redactions that they obviously told the department to make. So I have to ask, why would the department allow these redactions against the call of an order from this committee to allow us access to these unredacted documents?
Okay, thank you for the question. I will try to be brief and not repetitive, but just to go through a few things before. So I guess the first point, which I made in my opening remark, is that we have a contractual obligation that we signed between Canada and Stellantis. And as much as we want Stellantis to respect all those terms, we stand on more solid ground if Canada also respects all those terms. So there are terms within that contract that we think are very important at play at the moment that we want to make sure that Stellantis fully meets. Secondly, if you just maybe 1 minute, is that, you know, we also understand as we work with all these agreements and these companies that there is some commercially confidential information that we need to be able to do due diligence to go ahead and provide some investments. And we don't want to break that trust where essentially in future companies would be less likely and perhaps very constrained in terms of either sharing information that we need to do for due diligence, or secondly, not even
I'm sorry,
approach
my
us at
time
all.
is very limited.
Sorry.
So, what would be the justification for redacting the bottom of page notations in the amendment on Agreement 1? Like, how is that?
So I'm not sure which page you're
The
talking
bottom
about.
of page notations in Amendment Agreement 1. Can we hold while they look for that? Hold my time while they look for that? Amendment Agreement 1.
Okay. Sorry, so I actually do have an answer to that, which, sorry, I did not know before. So it's a privacy exemption for the what's noted in this bottom of all those pages.
So if those, like, there were other places where you've actually left in private emails, how is this suddenly now a privacy issue?
Well, we have emails of people that work at Stellantis.
Correct. Yes.
Which through the due diligence with Stellantis and back and forth, they feel comfortable having it out there.
But you're saying this is a privacy issue, like, so this tiny little thing at the bottom of the corner, which looks like maybe it's someone's initials. How can that be? This personal information elsewhere has not been redacted. How is this suddenly a necessary redaction? Honestly, that Stellantis is not here, and that you're suggesting that this is all above board privacy, personal privacy, and who knows what is really quite shocking to me. This is an order that we made as a committee. All of us here said we needed these documents, and you're basically supporting Stellantis in redactions that look completely unnecessary.
So, I mean, just to clarify on that point is, under the agreement that we did sign with Stellantis, we have to consult with Stellantis, as we would for any other company we're in agreement with, to make sure we agree on what we think is commercially confidential.
But you did admit that you didn't even ask them if they would allow the whole contract to be considered.
What we discussed, which we have done successfully in past parliamentary committees, is find a compromise in terms of being able to make sure the committee can review what it needs to do its due diligence.
And yet you took the entire schedule of work fully out. Like, you took the entire schedule of work fully out. It's like, it's a core accountability mechanism. If you want to be transparent, why wouldn't you have asked them to include that?
So there is information in programs of work that actually can tip the hands to competitors in terms of what they're trying to produce.
Every word in that part? Every word in that section? Every word in that section is all completely private. Because that's how you've blacked it out. There's nothing left.
So as I said, in our discussions with Stellantis, that is what, in their assessment, needs to be protected.
So you do understand that redacting that schedule creates kind of the appearance of a deliberate cover-up?
We're in our discussions with Stellantis, we're comfortable with the redactions that they brought to this document. In our assessment, what's being released to this committee, which is supposed to be in camera, is more than would normally be released, and certainly well above what an ATEP request would release.
Maybe we can just jump into it. How does our approach to the protection of proprietary and commercially sensitive information compare to other countries within the G7 more broadly? Do we have a line of sight there?
Yep. Thank you for the question. I'll just have Benoit, who would have a better, more comprehensive answer than I would on this.
Yeah, thank you for the question. I think the Deputy Minister mentioned at the beginning as well that there's not only sectoral, commercially sensitive information in terms of sectoral competition that are at play here, but there's also foreign direct investments and other countries that are also trying to attract the same kind of investments that we are trying to attract in Canada and sign contracts with those companies. And quite frankly, they would have a very similar approach than Canada in terms of protecting the commercially sensitive information in those contracts.
Okay. So this is if we're looking at this is a competitive advantage in terms of large, for lack of a better term, foreign direct investors into our country in terms of investing capital in our country versus other jurisdictions around the world. Correct?
So I think the way to answer that was correct is that there are certainly many countries, and well, in this for different depends on the sector, but let's say for automotive, the U.S. and Canada would generally be speaking or be competing in terms of trying to attract those investments. There is an advantage ultimately to make sure that some terms of those contracts are not in the public domain, to actually tip our hands in terms of the approaches we take. Also, from a commercially confidential perspective, there are some, in different instances, there are some commitments that companies are making that they feel would be disadvantaged to them in terms of being in the public domain for either investment discussions they're having in the U.S. or for a competitive advantage with other automotive companies that they're competing against.
So CIF Agreement 810-819553, which is not the one we're talking about today, that was produced through an access to information request, and it's now in the public domain. It's on the CBC website in a PDF. I was able to print it off with limited redactions. But you're suggesting that this CIF Agreement 813-816251 can only be reviewed by parliamentarians in camera? The confidentiality, so we have to wait until someone makes an access to information request to see it? That's your argument? An access to information request trumps Parliament's right to review the documents?
Yeah, so just to be clear, I've never suggested that.
But that's what you are suggesting. You're saying we can only review this document in camera with your redactions. However, the CBC obtained a copy of another CIF agreement, the same format. I'm looking at it. It's almost identical, clause by clause. It's now publicly available. Anyone in the entire world can review it. But you're saying this one is so special that we can't review it except in camera with your redactions. That's basically the argument you're making to Parliament right now. And I'm sorry, it's not making a lot of sense to me. Do we have to wait for an access to information request, or is Parliament supreme?
Yeah. So maybe to answer the question as best I can, I'm here today to talk about this contract we have with Stellantis on the Brampton plant. And under the conditions of that contract that we signed, at the end of the day, we recognize there are elements that are commercially confidential that we have to do the best we can to protect it. And what we've recommended to this committee is an approach that we've done in past parliaments, where at the end of the day, we found a compromise in essence of being able to protect this information that the company feels is important to protect to be able for their competitive position, while at the same time allowing the scrutiny that this committee wants.
But if it's subject to the Access to Information Act, which it is, as you pointed out, you pointed us to Section 16, it's 16.1, and a news organization was able to get the entire document through an access to information request and publish it online, you're not protecting anything commercially sensitive. You're just delaying parliamentarians from being able to review it. We just have to wait until someone does an access to information request. Then we can view it publicly and discuss it. How does that make any sense?
So I can't speak to the other contract. What I can speak to is this contract.
So you know nothing about the other CIF agreement that was signed at about the same time?
Well, what I can't speak to is when and how what's in the public domain got into the public domain. What I can say is that the information that's redacted in this document.
But you're saying we can't even publicly discuss it. You're saying this document has to be discussed in camera. Or I guess we can file an access to information request and then we can have it in the public domain like the other one. It seems to me like you're saying someone who makes an access to information request has more authority to review a document than the Parliament of Canada. And I find that deeply troubling.
Okay, so I'm not suggesting that in any way. If there were an access to information request on this contract, it would be subject to the Act and exemptions and redactions that would take place related to it.
So my
interpretation of the Access to Information Act is that what is commercially confidential would remain commercially confidential through that process.
Okay, but not the entire document is commercially confidential, because even this document you've given us limited access to, you've only redacted certain things that you claim are commercially confidential. Therefore, the entire document isn't commercially confidential by your own analysis.
Okay. So just to be clear, when I shared this document with this committee, it was under the understanding, which at the end of the day is not ultimately what happened, but is that we would have a discussion, and that document would only be shared in closed doors.
Well, the document hasn't been shared.
And the reason why we did that
hasn't been shared outside of this room. No one's referencing specific sections of the contract, in fact, except you. You mentioned section 16.1 about confidentiality, but you seem to be dancing around this. If an access to information request can produce the entire document with redactions that are commercially confidential, but you're saying this contract cannot be reviewed by Parliament except in camera, meaning no one gets to see it, then you're saying that access to information has more authority than Parliament to review documents.
So I'm actually trying to say.
Sorry, very brief answer, Mr. Jennings.
Sorry.
Brief answer, please.
Okay, so I'm not suggesting that. We're actually trying to find and proposing a way for this committee to be able to review the document and have a discussion of the document so that it can do its due diligence related to it.
Thanks.
What's the relationship between the minister, the minister's office, and the department in terms of negotiating contracts and then redacting them when there's requests for them to be made public?
Yeah. So the answer depends on at what point in time we're at. Obviously, if we're negotiating a contract and ultimately we do need approval from the minister to kind of proceed. So in those cases, a minister will have seen the terms of what the contract has been negotiated to be able to sign off. And if contracts are over a certain amount, we have to go through Cabinet and Treasury Board to be able to get those approvals. Post fact, so in this case is what we're talking about. So we have a sort of a new minister that was not involved in the negotiations. So there's no need for her to see the entire contract. So we brief her on as needed in terms of some elements of the contract to be able to satisfy the questions that she has related to it. And she's asked many questions recently on Stellantis, given that the decision for them to move the Jeep Compass production from what was planned for Brampton into a facility in the U.S. But we don't interact with her or her office in terms of what redactions take place. It is a contract between ISED and the company. So at the end of the day, the contractual obligation is to the department, and we make sure that we respect that by asking the company what are the redactions that they be willing to live with that's commercially confidential to be able to share with the committee. We did, in those discussions, encourage the company to be as open as possible, given the requests to make sure that this committee has as much as possible. And they've agreed to do that under the condition that the discussions would take place in closed doors in terms of what is the content of what was shared with this committee.
I appreciate that. I am actually really devastated that Stellantis has made this move, because this is my constituents and my city and my region whose jobs are directly impacted. So, and then for Stellantis' failure to appear today, it just adds fuel to my fire to stand up for my constituents. But for yourselves as a department, can you explain the difficult situation that you're in as a department, where you're trying to protect Canada's ability to negotiate contracts, to bring in investments, while also making sure that our taxpayer dollars are spent effectively and are actually used for what we need them to be used for?
Yeah, so I mean that's in some ways that's the crux of the issue. Is at the end, we need to have full information, including commercially confidential, to be able to come to an agreement. Otherwise, we're not effectively deploying the money that has been asked to do. So that's why we take the approach of making sure that for the due diligence phase, and in terms of some of the commitments that are in the actual contract, we need to have commercially confidential elements of it to be able to have the contract we have with those companies be as effective as possible. And that, just to be clear, Stellantis, it's all the companies, 152 plus companies that we have agreements with that essentially agree to share commercially confidential information with us so we can do our work. What they also insist on, which are clauses that are standard in these agreements, is that we protect what is commercially confidential so that their competitive position is not ultimately broken and compromised by participating in a program that is supporting innovation and risk-taking by the private sector.
Thank you.
Okay.
I appreciate that. So I'll ask, have there been any freedom of informations put in for any of the documents that we're discussing today?
Sorry, I missed the beginning of that sentence.
Have there been any FOIs put in for the documents that we're discussing today?
Sorry, I'm just not familiar with that term.
Freedom of information or access
okay.
to information, sorry.
Has there been? Okay, no, I was not aware of, and my team is telling me there's not been an access to information request related to this document.
Okay, thank you. So I will ask you then, how can companies trust government, and how can workers trust government? How can taxpayers trust government? Because while you're on the front lines of bringing all of these three stakeholders together, what do you think are next steps to take when we're dealing with negotiations like this, when we're trying to make sure that we're attracting good investment into Canada, and to make sure that people aren't taking our hard-earned taxpayer dollars and then moving off to other parts of the world?
I'm afraid we're well past our time, but could you offer a short response if possible?
Sure. I mean, I guess as short as possible will be like trust. Trust is at the core of these agreements. So at the end of the day, the only way we can actually come to an agreement is that we both trust that both parties, the government and in this case Stellantis, trust each other, that we'll be respecting all the terms of the agreement. And for us, it's fundamental. We're at a point in time where we're expecting Stellantis to respect all the terms in those agreements, and they're expecting us to also respect those terms, which include not divulging information that's commercially confidential.
Sure, please.
Thank you very much, Mr. Chair. So, Mr. Jennings, you talked about in order to do these redactions, you consulted with your department, you consulted with Stellantis. Did you consult with the minister on these redactions?
Thank you for the question. No, we did not interact with the minister or the minister's office related to the redactions.
So you're given free rein and the minister has no oversight to what the department does?
I'm just stating the process we followed for the redactions for this contract. We were satisfied that the spirit of what was requested was followed by Stellantis, as has been the case in previous cases where we've had interactions with companies related to redactions. We felt that the company was open to a very small amount of redactions and sharing the documents in closed doors meetings.
Well, I hope you leave today with the impression that members of Parliament are not satisfied with the state of the documents as they are. We requested unredacted documents, and as has been outlined before, there is a process that has been established previously on how we could do that, and this is not being followed. Has the minister seen the fully unredacted contract?
I certainly would, if she has, it wouldn't have been through my office, so my sense is no. I've actually not seen the fully unredacted version myself.
Really? Okay. As far as departments go, I mean, I find it a little bit rich that only maybe 4 or 6 other people other than, I mean, because you said everybody at the table had seen it earlier, now you're saying you haven't. But to say that there's only been 4, maybe 6 other people that have seen this contract, I mean, has Privy Council, has PCO seen this contract unredacted?
So my sense is no, they would not have seen it. We really treat these documents with a lot of care. So at the end of the day, it's on a need-to-know basis to be able to see the full contract. I've not needed to know this contract. I wasn't negotiated while I was deputy, so I've not needed to see the documents. Had it been negotiated when I was deputy, then I would have seen the document.
Okay, so the previous deputy minister saw the contract.
Well, I'm assuming that. I don't know that for a fact.
Okay, what about legal? Like, obviously, there's some legal folks that would have to see it. Is there a legal department that would have seen this?
So that is a good question. I'll turn it to my team just to say how typically legal is involved with looking at contracts, if that's okay with you.
Briefly, please.
So I think as was said earlier, we have a standard contract that is developed with legal. Legal gets involved in discussions around specific clauses if there is debate and negotiation and we're trying to land in a position and there's legal risk. But typically, would they review the full thing, Denis, before? I don't think they do. They would see clauses if
Really?
they were outside the standard. Because we have a template agreement where our clauses are the same. And then what we typically negotiate with the company are the specifics with regards to their statement of work, their benefit commitments, and the like. Those are more about the project and what we're trying, and they're less about the legal commitments.
Okay, so you're telling me the legal team for a $15 billion contract doesn't see the entire contract?
They would be pulled in where clauses are deviating from what we would typically negotiate, would be my understanding. Denis, is there anything you'd add to that?
Yeah, I think there are obviously lots of clauses on those that they have seen, so they would have a real sense of the whole contract.
Okay, so you're telling me though that like somebody from legal, there should be more than, I would assume that there's somebody that's overseeing the entirety of this contract. You're telling me that it's a piecemeal approach to how we're dealing with these contracts. Then how come legal hasn't seen the entire contract?
We enter into a negotiation. We have a term sheet that outlines the terms for which how we're going to approach the negotiation, and we have a standard template for our contribution agreements that has been vetted by legal. We then enter into negotiations. That negotiation is led under my team. Under my team, I have an operation group, which is led by Denis. I have a financial group that is led by another DG. And then our industry sector, Benoit is here today, is involved from a market perspective. As well as then legal will be pulled in if there is disputes with regards to specific clauses that deviate from our template. We keep a team small with what comes to the negotiation of these, and when we go forward for approvals, whether that is to cabinet or to treasury board, or if it's going up for ministerial approval to execute through a project summary form, we summarize the key points of that agreement, what is being achieved, the financial aspects of that, the benefit commitments, so that everyone has a clear view of what is being agreed to.
That's more than 4 people.
Do you think the United States or Mexico, who are aggressively competing for these very same foreign direct investment dollars and for these very same jobs, would ever expose contracts like this publicly? And if so, under what circumstances?
Okay, so I would say that by and large, it would not be practice to share that type of information, and I can tell you that in some cases, actually, as a department, we try to understand what are other jurisdictions doing so that we can be more competitive. And the more information we can garner of what other jurisdictions are doing, the better position we are to try to attract those investments. So in some ways, it is a comparative advantage to actually have less information in the public domain than another jurisdiction to actually properly attract an investment. The other thing I'd say, which is important, is that it's also important in us leveraging the most out of each of the investments. So if we were public with all of our agreements, we have less leverage to negotiate the best deals with companies. So at the end of the day, we do think it's important to be in the public domain with what we need to, but keeping the commercially confidential stuff out of the public domain so we can leverage the best return as possible in terms of the agreements. And as I mentioned to this committee earlier, we feel relatively good in terms of what we've leveraged from the SIF and now the SRF. So we have just over $11 billion has managed to leverage over $75 billion of investments in Canada across a whole range of sectors and across all regions of the country.
How much time do I have, Chair?
20 seconds.
Okay. Okay, I'll be very quick. Do you think the contract as is provides enough flexibility for Stellantis and other large investors into our country to find a new model for the Brampton plant? Because ultimately it comes back to the workers.
The contract includes clauses to be able to work with Stellantis to ensure that they meet all the terms of the agreement, which includes having a production in Brampton.
I have trouble just understanding why there are so many redactions in this agreement that taxpayers, Canadian taxpayers and Canadian public are interested in. So I'm just going to pick out a few that stands out to me. So in section 6.35, it mentions the Stellantis' commitments, which are legally binding obligations to make research and development investments into facilities in Canada. But the dollar amounts of these R&D commitments are redacted. Why is that? I mean, Canadian taxpayers are expecting value for their investment, that if they're going to, if taxpayer funds are being used to fund this multi-billion-dollar so-called investment, the Liberals like to call it investment, that there will be some return on that investment. So why would such an important figure be redacted?
Okay, so I'm going to answer with a broad statement just related to what I asked in my opening statement, which I'm happy to discuss, is that we do not discuss the actual terms of the contract in a public setting. The agreement we've had with Stellantis is that we would share the redacted version and have discussions of it in a closed-door session.
But I'm asking why these specific terms are redacted. I'm not talking about the terms themselves. Why are these dollar amounts? There's some of the other dollar amounts aren't redacted. I mean, the crux of this is that Canadian taxpayers are trying to figure out whether Stellantis are going to create those jobs, whether they're going to make those capital expenditure investments, whether they're going to do the R&D here in Canada. And you redacted some of the most important information, and you left in all the, boilerplate legal clause, like the confidentiality agreement, the governing law clause, but the most important information was redacted. I mean, who are we trying to protect here?
Okay, so I'm not going to comment specifically on anything within the contract that was shared under a condition that we talk about it in closed doors. However, I can say that in our discussions with Stellantis, they outlined to us for every redaction of what they felt, why it felt to be necessary to be protected commercially, and we were comfortable with the redactions that they proposed.
So the interest of Stellantis comes first before the Canadian public. Is that what you're saying?
No, I'm not saying that at all, actually. I'm actually saying that, Stellantis has shown an openness to sharing more information with this committee than would be publicly available to make sure that there is a full discussion and scrutiny on the contract.
Well, we talked about parliamentary privilege earlier this meeting, and we know that these compelling disclosure of this document is exempt from an unredacted state is exempt from the confidentiality provision in the agreement. So clearly these redactions are done voluntarily between the department officials. Is that right?
Well, under the terms of the agreement, Canada must discuss. In this case, our department, ISED, has to discuss with Stellantis any disclosure of documents and what redactions they feel they have. Otherwise, we're breaking the contract, which requires us to treat information confidentially unless the company is willing to share it.
So you mentioned. So what is so commercially sensitive about these documents? I mean, the clauses. We're not talking about spreadsheets with names of employees and all that. We're just talking about clauses in the overarching agreement. So I just fail to see what's so commercially sensitive about this. Like, it's not industrial designs or schematics and trade secrets that we're disclosing. It's just the text of an agreement. So it's just the most basic outline of the relationship between the government and this multi-billion-dollar company. And don't you think that taxpayers should have some closure in seeing what's in this document?
Yeah. I could answer that question, but I'd say the best authority to talk about the justification of what is commercially confidential proposed and the redactions proposed would actually be Stellantis. That's who we consulted under the terms of the agreement that we signed, is for them to identify for us what they felt was commercially confidential. So I think that would be the best to ask Stellantis that question.
That you discussed with Stellantis, or your department discussed with Stellantis previously, to determine which issues were considered commercially sensitive, too sensitive for Canadians to understand and to be made aware of. So, how do you reconcile that?
I have to interrupt. That is our time.
So I served on the Winnipeg Labs committee, where we looked over confidential documents to see whether the redactions were necessary or not. There were a lot of documents for sure. Now, a lot of that dealt with national security and intelligence issues. In your instance, can you walk us through what are the considerations that your department would take in the redactions that are proposed in these documents?
Yeah, so I mean, to clarify for this committee, is that the redactions were following discussions with Stellantis in this case. In past discussions, there were different companies that we've had discussions in terms of redactions, and it's what they feel is commercially confidential based on the current situation. So as I gave an example earlier, if they're going to launch a new car product, as an example, they want to protect that information until that project is launched. So we want to protect that information. So the only people that would be best in understanding what should be commercially confidential until when, it would be the company. So that's who we interact with to make sure that it is protected as long as we can. In terms of the suggestion to have an approach which is perhaps similar to what you had, but in a different context, a different committee. I mean, that is what I think would be a constructive way to potentially spend time, is really about having a look at what's redacted in those documents, have Stellantis at the table, which are the ones who recommended those redactions, to make sure that there's full accountability for this committee in understanding why the redactions were made, and whether, in your judgment as a committee, you feel that those are commercially confidential or not. We have our own judgment as a department, but you have to make your own judgment as a committee whether you agree with that or not. We're pretty confident that what is being redacted is commercially confidential, and we feel confident that they've gone, beyond what would normally be the case as an ATIP for sure, in terms of releasing as much information as they can.
Okay, thank you very much. I don't know if maybe I need to ask Mr. Bedard, but if it would appear that Stellantis is breaking the agreement by moving to the U.S., do they have any right to continue to demand the commercially confidential part of the agreement, or would it suggest, if they can move, that it's within their rights to leave based on the contract?
We look at the contract in terms of potential confidentiality of information, not in terms of the clauses. So I'm not in a position to answer to your question.
Okay. Maybe I'll ask Stephanie. It appears that Stellantis is breaking the agreement by moving to the U.S. And so would they continue to have the right to demand commercial confidentiality?
So in the agreement, there is a resolution process. So currently, and as I think our minister indicated in Nindu on October 3rd or 4th? November 3rd. We have entered into the resolution process with the company to determine whether or not there is a breach.
Okay. So I have another question then. We've admitted that the department is using boilerplate contracts and that they don't bring legal counsel to the table when you're actually in the business of negotiating a contract, like a $15 billion contract, something I can't imagine happening in the private sector. Now, Stellantis is moving their plant to the U.S. It would appear that a boilerplate contract that you're using isn't really equipped to ensure things like a jobs guarantee, clawbacks, and so forth. Would you agree?
So I did not say we use a boilerplate. I said we have a template.
I believe that Mr. Jennings did, perhaps.
We have a template agreement, and then there are template agreement that we then negotiate very significant portions of these agreements, including the benefit agreements, including the financial provisions, on a case-by-case basis.
So you do have lawyers in the room.
So the benefits agreements in this agreement would have been negotiated specifically with Stellantis to reflect the project itself.
Right, but
those
so that
are
means
not boilerplate.
So you would have a lawyer in the room when you're speaking with Stellantis on this particular thing. You would have a lawyer sitting beside you, which would be normal for any other private company to have lawyers in the room when you're making these negotiations, because they're going to see those details.
We do not have legal sitting in with us in every conversation we have with the company during the negotiation and as we work towards a final agreement, no.
Okay, so we've clearly established from the law clerk, thank you very much, that this is within our parliamentarian rights to see these unredacted documents. And yet, somehow you believe that 9 of us MPs can't see those unredacted documents in a closed-door meeting. Like, we're not asking to put this out into the public. Are you concerned at all that people watching this may see this as a cover-up from the government?
Just to be clear, once again, what I've done is suggested a past practice, which I think carefully balanced the needs of a parliamentary committee with the commercially confidentiality clauses that we signed with companies. What I suggested to this committee is we follow the same process, which is essentially to make sure that we work with the company in terms of understanding what should be redacted in terms of a document, and that we share that in closed doors. In past parliamentary committees, they've agreed to that process. This committee may not, but that is what the past practice of finding the right balance.
So, however, based on the redactions, I just don't see how we as parliamentarians can determine whether or not we have any leverage as government, in regard to timelines or job guarantees or anything like that. Like, I just don't see how we have that the way you guys have done these redactions.
So the work we did with Stellantis was about trying to minimize how many things were redacted. So you mentioned jobs just now, so that has not been redacted. The covenants related to closures was not redacted. These are elements that you could argue are commercially confidential, but the company is willing to share it with this committee in a spirit of openness on this.
However, the wording that's used, and I have no idea what I'm all allowed to say, but the wording that you used is so airy-fairy out there. It can be decided in Stellantis's good pretty much every time, based on what I've read.
Sorry, I'm not
The
quite
wording,
clear on
the wording
question.
in this contract, which you guys have, which again I don't know whether I'm not allowed to use any of the wording, is so general. It's just so easy for Stellantis to be able to argue for themselves.
Well, it certainly respects what we think with each company. They're looking to protect what's commercially confidential.
I'm not even talking about the commercially confidential. I'm talking about job guarantees.
Sorry, I have to interrupt. That is our time.